rights to inventors for their discoveries. The government has encouraged sharing of the knowledge while ensuring that inventors can benefit financially from their creativity. So this system balances the public's access to new ideas with the inventor's right to profit, which has been a crucial in fostering technological advancement that drive our economy. So again, how does USPTO's role come into this situation, right? The USPTO's main mission is to basically support innovation and economic growth in the US by basically providing a reliable and predictable intellectual property system. So this system helps basically businesses, small businesses, to protect their ideas, or individuals too, for their inventions, and fostering an environment where innovation can thrive. And here is our director, Kathy Vidal, and she has basically emphasized the agency's commitment to improving the access to the patent system for all inventors, regardless of their background or resources. So this inclusive approach is designed to maximize the innovation potential across the country. So, and then these are some of the highlights and stats of the patent office again. The scale of operation that we have. This gives you a snapshot of USPTO's operation for the fiscal year 2023. This basically shows you number of employees, which is approximately 13,000 plus, and that includes almost 9,000, roughly examiners and 600 plus trademark attorneys here. And along with them, we have some administrative patent judges and trademark judges here. And the key statistics are basically, if you see here, we had in 2023 almost 600,000 plus applications filed, and then almost 50,000 patents were issued. Same goes with the trademark. We had almost 700,000 plus applications filed, and 400 plus trademark certificates were registered, basically. So basically what it means is you got a registration and your trademark was approved, basically. So you can basically enforce all the legalities that need to go through that. So far, so good? No questions? Okay, perfect. And so I forgot to mention that obviously you saw our headquarters picture at the bottom, but we are based in the Alexandria, Virginia, which is where the USPTO's headquarters are. But other accessibilities are the USPTO regional offices are located across the country. This offices makes USPTO's resources more accessible to inventors, entrepreneurs, and businesses in different regions, and provides support closer to where they live or work, basically. What kind of services they offer, right? They offer everything from educational outreach, which we are doing currently, or one-on-one consultations, support for patent and trademark processes. And then again, we also have offices here in Detroit, one in Dallas, Colorado, Denver, and then San Jose. And soon we're going to have a Southeast regional office that will be in Atlanta, Georgia. So how does this impact the economy, at least in the United States? So IP intensive industries basically contribute significantly to US economy. And these industries are responsible for large share of country's GDP and supports millions of jobs. So if you see the findings here, how IP intensive industries have substantial portion of economic output and higher than average wages. Basically, if you see, it has generated 63 million jobs, but this data is also since 2019. And then it has also make up almost 44% of the US jobs basically, and it also has added to 7.8 trillion of the GDP growth in the United States alone. And you can find this data at this links that will be provided in the PDF file that Cherries and the group will share with you guys. So what's next on your IP journey, right? I think we went over this tool last time too, and a couple of times. Basically, this tool again helps individuals, resources, businesses, small businesses to identify what kind of IP asset do they possess, right? And so how do you determine what it is? And I think there's basically simple 6 questions that you answer through, and it's gonna lay out the answers that are, do you possess copyright or a patent or a plant patent or a utility patent? So this is the best tool that you can have at that point of time. So again, we'll give a brief overview of all intellectual property that exists basically, right? So all of this legal, various form of intellectual property gives you some kind of legal protection that's designed to safeguard your creation of your own mind, right? So going to the utility patent, basically this protects new and useful invention or discoveries such as machine processes or composition of matter. So for instances, the technology behind smartphone is protected by utility patent. We talked last time about design patents too, which in iPhone, that iPhone's external design has a design patent. So we'll jump to the design patent aspect going from there. This covers original ornamental design for an article of manufacture. Think about unique, again, design of a modern car or the iPhone that I mentioned, or a piece of furniture. Those are all often protected by design patents. Next is the plant patent. So granted, plant patent can be granted to anyone who invents or discovers a asexually reproduced, distinct and new variety of plant. So for example, would be a new breed of flowers or fruits that may be protected basically under plant patents. Next is copyrights. Again, copyrights, it protects the expression of the ideas in mediums like books, music, films, which ensures basically the creator can control the use of their work. And next comes is trade secret. So this usually includes confidential businesses information that gives you a competitive edge, such as formulas, practices, and processes. And as we know, the famous example is the recipe of Coca-Cola that we talked last time. And then finally, we have trademarks. This protects symbols, names, slogans, usually used to identify goods or services. So like, for instance, if you see the Nike swoosh, we know it's well-known trademark symbol that relates to Nike shoes, basically. So let me go to the next slide. So, okay. So we'll now we're going to dive deep into the patents, and the one of the most powerful tool for patent is it's basically a tool that gives the inventor the arsenal or a company to basically maximize their creativity at this point of time. And so again, a US patent is a property right granted to an inventor by the USP, which gives the federal government, gives that exclusive right to exclude other from making, using, or selling the invention in the United States for a limited time period, typically 20 years for utility patent and plant patent, and usually 15 years for design patent. So in simpler terms, a patent is like a legal monopoly on your invention, and it prevents others from profiting from your idea without your permission. And why does it matter, right? Patents are vital because they provide inventors with a tangible asset that can be licensed, sold, or used as a collateral for financing. They also offer a competitive edge in the market by preventing competitors from copying your invention, basically. So how does it benefit you? So you might wonder why government grants such powerful rights to inventors, right? The answer lies in dual purpose of the patent system. Basically, it's encouraging investment, right? First, when a patents encourage investment in innovation, basically by providing the inventor with the incentive of exclusive right. And so investors are more likely to fund the development of new technology if they know that the resulting product can be protected for immediate copying by competitors, right? And secondly, it promotes public disclosure, right? So when patents usually require inventors to disclose their invention to the public. So this disclosure is so crucial because it adds to the collective knowledge, allowing others to learn from it and further innovate. So even though the inventor has exclusive right for a time being, the knowledge shared through a patent can inspire new developments and technologies that can accelerate overall progress, basically. The how does it affect the economic? How does it impact the economy here, right? Again, this system is far-reaching those economic implications, basically. It basically, again, helps you foster an environment where innovation can thrive, ultimately leading to new industries, job creation, and improved quality of life, basically. So here are the three types of patents. These are the most common types of patent, and usually which accounts almost to 90% of patent issued in terms of, if you see in the next slide, you'll see why 90% is relatable. It's mostly for the Florida state for the past 3 years that I have collected some data. But again, um, utility patent, they basically cover new and useful processes, machines, manufacture, or composition of matter, as well as the new and useful improvement thereof. So think about the technology behind the electric vehicles or pharmaceutical drugs. These innovations are often protected by utility patent. But again, every drug, when there is a breakthrough, there is an improvement on it, and it improves overall, life of the human being. So same thing. That's why it says new and useful improvement thereof. Um, Design patents here. Again, design patents are focused on protecting the unique visual qualities of an object, while they don't cover the functionality. So they are crucial in industry where aesthetics and branding play a significant role, like fashion, consumer electronics, and automotive designs. Um, and then finally, we have plant patent. Though they are less common, plant patents are essential in agriculture and horticulture. They provide protection for new plant varieties that have been asexually reproduced. So for example, if you develop a new type of drought-resistant crop, a plant patent can protect your innovation that way. So here's from March of 2021 to March of this year, I created a chart by pulling out some data. And this basically shows you that 90% of utility patents were filed in and were given patents in the state of Florida through USPTO. And the plant patent was, less than 1%, and then 10% were design patents. Um, and then it also, this recent trend also shows you in what areas did the Florida inventors did that. And this is again from this past 3 years that I pulled it out. And if you see here, this tree map basically shows you diagnostics and surgery that accounts to almost 12% of the patent, and then electrical digital processing this section, almost 8% of the patents came from there. And then the telegraphic transmission, they 7% almost. And then the medical and dental diagnostic surgery, they were around 5% of the data. And the rest were all small here and there um, patents. Yeah. So here's the significance why this growth of patent matters, right? Basically, it indicates a thriving, innovation environment which can attract investment, boost local economy, and lead to creation of high quality jobs. So this is the perfect example from like 1936, the first patent that was given, till now. You can see we've reached 10 million, and I think just start of this year we reached the 11th million patent too that we issued. So you can see the trajectory. It's like Moore's law, basically. It's like growing like exponentially. So what how does it add the value to your business, right? You have to have some kind of strategic in IP management. And the best way is to having a robust IP strategy. Is it just not just about protecting, but it's a crucial part of all your overall business strategy. IP can be a very powerful tool to enhance your competitive advantage. It can attract investors. It signals companies' commitment to innovation, and it also gives potential growth for future entrepreneurs. Again, it also helps in deterring litigations, right? So when you have well-protected IP portfolio, it can deter basically potential lawsuits and help defend against infringement claims or protecting your business operation. It will also add um, increasing company value, and it can usually happen through mergers and acquisitions, where patents and trademarks can be critical for negotiation purposes. So simple example is also WhatsApp. WhatsApp was created by some small inventor which later was basically acquired by Facebook. So Facebook owns WhatsApp at this point of time. So here's the perfect, when should I determine that what kind of intellectual property I have, right? Again, we talked about how you can use that IP identifier tool to determine that. And then you can create an effective intellectual property program to identify, protect, and use of your intellectual property. And when acquiring or selling a company or a line of business, it's also crucial to carefully access and address any intellectual property rights, basically. So the path to a patent, this is a perfect path which gives you an understanding. It will navigate how would you get a patent if your invention is new and useful, correct? Or it is an improvement upon. So the first step starts from idea conception, where you as an inventor identify a problem and come up with a novel solution. Next is the provisional application. And this is optional. And I can tell you why it is optional down the slides. You will understand it. And I think we talked about it in last presentations too. If you are not ready to file for a full patent application, you can file a provisional application first. And this is a lower cost option that will allow you to establish an early filing date without all the formalities of non-provisional application. So it gives you 12 months to further develop your invention and access its commercial potential, basically. And then once you finish close to your 1 year, just before that 1 year's time frame, you will file for your non-provisional application. When you're ready, it will require more detailed information, including claims, define the scope of the invention and the protection. And once that's done, Then it comes to the patent office, which will review the application to ensure it meets all legal requirements. And it will also check for novelty, non-obviousness, and the usefulness of that. And once it passes through that legal requirement, you will receive a patent, which will give you an exclusive right for your invention for a limited time period, basically. So far, so good. Awesome.
Yes, I had a quick question for you, Gotham.
Sure.
What are the price ranges for the provisional, non-provisional applications or the full patent? Do you happen to know those?
Yes, we have the next few, in next slide, you will see the difference.
Okay.
And if you have a question, ping me.
All
I
right.
can
Awesome.
elaborate. Yes. But yeah, I think we'll go through that. But anyways, so here's basically, again, uh, give this is very, how do you present your idea, right? This include that you clearly define the problem that the invention solves, how it works, and why it's innovative. When you are writing your application too, use of diagrams, stress the importance of the detailed diagrams or illustrations, because this will help patent examiners like myself to understand your invention clearly. And again, just be mindful of confidentiality. Discussing the inventions with others or publicly can lead to loss of patent rights, so if not handled correctly. So again, maintaining confidentiality of the details is crucial prior to filing for a patent application. Again, caution. Again, this is purely a caution, right? Public disclosure risk. Disclosing an invention before filing a patent application, that can include is publishing an article, giving a presentation, or even posting about the invention online. Those are the risks that you will come across. So you want to be protective of that. So don't discuss, and the consequences you could lose the ability to own a patent invention and the date, right? Because if you leak that out, somebody might take that idea and file for application, and US is first to file. So you have to be careful when you do this. Again, safe practices. Just such as use as non-disclosure agreements when you're discussing your inventions and with potential partners or investors before you file for patent application. And again, can I just keep it secret? You can. It all depends. What are you seeking out of it, right? So it is purely, and this is where it's always advisable that you can consult with some legal consults. So here is hopefully, if this doesn't resolve your question, feel free to ask again. So here's the perfect comparison of provisional and non-provisional application. So provisional application is a lower cost option that allows inventors to establish an early filing date without requiring a formal patent claim, oath, or declaration. And it gives inventors a 12-month period to develop their invention further and decide whether to proceed for a full patent, which is a non-provisional application. And in contrast, non-provisional application, which is a full-fledged application that requires obtaining a patent, it must have all requirements set by USPTO. That is, including a detailed claim defining the invention and description, drawings, as I said, as much detail you would like, you should add that in that. Again, for strategic use, this is where filing a provisional application first helps you secure the early filing date while still refining the invention or seeking any kind of funding. That's where this provisional application that it tells you gives so much advantage. And to file for provisional application, I also mentioned lower cost option. It's a very inexpensive cost. Again, so the advantages, right, of provisional application. It generally is less expensive to prepare and file. It makes them attractive option for inventors with limited resources. Again, by it also establishes the early filing date, which can be crucial in the first to file patent system, especially if there's a risk of others filing similar invention. And then it also helps you give the patent pending status, right? You can put patent pending, which can provide some level of protection and credibility when you're discussing within this invention with your potential partners or investment. Excuse me. And then again, you have time to develop, right? You have 12-month period before you file for the non-provisional application. And this will help you do market research. It can also prepare you to make your non-provisional application more robust. So this is basically the timing again, right? Timing is everything when it comes to filing a patent application, especially in the today's fast-paced competitive environment. So United States is first invented to file system. That means that the first person to file a patent application for an invention gets the right. This makes it crucial to file as soon as you have a complete and well-documented invention. Again, the impact on public disclosure, right? Publicly disclosing your invention before filing can be risky. If you reveal your invention at a trade show, social media, or even in a casual conversation, you could lose the right to file to patent it. As I said, in US, you have 1 year grace period from the time of public disclosure to file for patent application. But this is where your provisional application comes into picture. It helps you. But again, in other cases, many other countries where public disclosure can forfeit your patent right. But those are outside the United States usually. So another thing, if you are planning to seek patent protection internationally, it's even more important to file before any public disclosure, as many countries do not offer the 1 year grace period. So filing early helps protect your invention across multiple jurisdictions, basically. So that was all about patent basic, and we're gonna jump into the resources. These resources might be very similar to what we went through in past two presentations. But again, this is what is the best thing that you can take advantage of, right? USPTO again offers a variety of resources for intellectual property, and also helps with application, education, training, support. Um, any kind of information you need, we have it all here. And USPT also has the Inventor Assistance Center, which is dedicated to delivering patent information and service to the public. Our team is highly skilled former supervisory examiners and experienced former primary examiners who are well equipped to provide comprehensive answers on general inquiries about patent examination policies and procedures. But they will never help you draft a claim or write your specification. And then again, we also have the patent and trademark resource centers. They operate, they are basically spread across the nation. You will find them at academic libraries. You can, or the universities, colleges. Basically, the idea of PTRC is to disseminate valuable patent and trademark information to the public. Again, PTRC representative can help with many services like giving access to resources, explain the application process, fees, demonstrate patent and trademark search tools, offer classes on intellectual property, again, historical research, and more. Um, and we always advise that when if you have to reach out to PTRC centers, we usually say call ahead and make an appointment. So they dedicate that time to you. And then again, we also have over 60 clinics that generously offer pro bono legal services to public, including inventors, entrepreneurs, and small businesses. This exceptional clinics provide patent and trademark legal assistance to eligible individuals who are accepted as a valued client. And again, to see the criteria on our website, you can find if you qualify for any of this services. And then we also have this law school clinic certification program that allows students to enroll in participating clinic program that helps you gain practical experience by representing clients before the USPTO under strict guidance of law school faculty clinic supervisors. And again, the pro bono assistance. This program basically matches under-resourced inventors with volunteer patent professionals. So basically, they will offer complimentary legal aid to support and guide independent inventors and small businesses through the process of preparing and submitting a patent application. It has an extensive network span across the entire nation and consists of programs operated independently, connecting volunteer patent professionals and inventors and businesses facing financial limitation. Each regional program serves residents of one or more states, ensuring comprehensive coverage. And the eligibility for our services is based on income level as well as applicants' understanding of patent procedures and innovative inventions. And these are some of the events that we have on our event page. We constantly have tons of presentations and learning and education, which is free to register. So if you go on our events page, you should see what are the upcoming events. And then that's it. And feel free to reach out to any of these regional offices for any more information. Thank you again for your time. If you have any questions, please let me know. And again, stay connected with USPTO here with our social media and official websites too.
Okay, so we are going to open it up for any questions that anyone may have during our last 10 minutes or so on the Lunch and Learn. Please raise your hand or come off mute if you have a question about the USPTO patent basics and what you should file. Or place it in the chat.
Yep.
So in the comment, there's someone with the acronym of BC who mentioned meeting up in Miami for those who are going to be down there for our next event in December. And putting some things to use. Obviously, BC, as you learned today, I would say, obviously meet up with other fellow Black innovation leaders here in Florida and assist each other. You've got resources down in Miami, but also keep in mind those disclosures that you need to put in place before talking about your invention that we learned today. So that would be a pretty great and dope event if you were to put that on. Thank
Well,
you. Paula says dynamic presentation.
no, and I think uh, my manager is on here too on the chat. She's been
Yes,
posting.
Tamika is. Yes.
Monica is here. That's great. No questions, nothing.
Yeah, if there's no questions, we're going to
There
go
is,
ahead and end a little early.
you could, and
Well,
hope
I do
Teresa
have a few
answered your
questions.
question.
Hold on, we have one coming in. Hi, state your name and your
Yeah,
question.
yeah. So my name is Mark Lissad. I am with the well, I heard you guys talking about Miami, and I've collaborated with you guys in the past. We're actually launching the Black Innovation Summit pretty soon. So two
Okay.
questions in terms of uh, the patent office. The first question is, in your experience, does hiring a patent attorney make a huge difference in successfully applying for a patent? And who in Miami should I contact to do a similar presentation within our community?
So tackle your first question about getting legal consult. We always advise people that if they do that, it really streamlines the process to get your patent in an efficient manner. So that would be our definitely most advisable path. Secondly, on giving presentation, um, we are most welcome to do those, but all depends on who the audience, and depending on if we have the capability of being there, we surely can do that too. I'm also
Yes.
based in Orlando here, so
And Mark, so that you know, the Black Innovation Leaders of Florida, this IP Launchpad series, it doesn't just end next week. We are moving into a long-term collaboration with the USPTO office, and we are going to resume classes starting in November, where they will give a class. I think it's going to be monthly on diving a little bit deeper into patent basics, and it's going to run for the entire year until next year. So we are going to be holding these classes. We're going to be advertising that so that any individuals in the state of Florida can join and register and take the classes online. It's not necessarily in person. We will have the USPTO office with us in person at our Orlando tour stop, which is going to be on Saturday, October 13th. They will be present for a panel presentation to talk about patents, trademarks, and copyrights, along with other individuals at that at the Orlando tour stop, which is going to be October 13th. Saturday, it's going to be from 9 until 3:30 p.m. In downtown Orlando. So we will start advertising that in the next couple of weeks for people to register. The event is going to be free, so there's no charge. So there will be a panel discussion on that. Still going to be high level, not necessarily getting into the details about filing your patent. If you are a member of Black Innovation Leaders of Florida, we are also offering a second service as a part of this educational series, which will give our members access to a platform called Patent Hack. And that platform is an AI-based platform. So keep that in mind. However, you can get assistance with filing your patent and trademark application. So we will have that service also available as part of our IP Launchpad program.
Okay, great. Thank you for the details. Now, a few quick questions. I missed the first few events that you had. Are they recorded?
We did record them. Have you signed up for membership with us? Make sure that you're a member, and the board is actively finalizing a platform for us to be able to put those classes on there for our members. It's going to be a membership-based platform. Right now, it's the best time to register because membership is free. So definitely get registered with us, and you will have access to those classes.
All right, great. And the next question is, you had mentioned an event in Miami. I didn't get the details.
We are more than likely, I think the board decided to possibly do it in West Palm or Fort Lauderdale. That usually will be during the month of December. We do not have dates specified for that because it's going to be dependent upon the venue, but we will be coming to South Florida in December. We normally do a regional tour stop every quarter. So in the spring, from like January to March, it's usually Tampa. Then we do North Florida in the late spring, early summer. By the fall, August to October, we're normally doing somewhere in Central Florida, normally Orlando. And then in the late fall, winter, we usually do South Florida.
Okay, great. Thank you so much. So I'm assuming that our speaker here would be the person, since you're based out of Orlando, are you the southernmost based representative for the USPTO?
I work for the outreach as a assistant outreach coordinator. So yes, currently I am, but there could be others too, yeah, who can come. In fact, Tomika, who's my boss, she visits South Florida too, quite the Florida region too. So either one could be here to do that. So we have a big
Okay,
team
great.
of people, yeah.
Okay, great. Thank you so much.
No, anytime. And if you still can come up with any question at this point of time related to these slides, please feel free to email us on the here. Let me bring the slides up quickly. You can still email
And for
us.
those of you, I'm sorry, for those of you who want
just
to become members, the link is in the chat. Go ahead, Gotham.
Oh, yeah. I was just going to say you can email to Eastern Regional Outreach Office at USPTO, which is the Eastern region, but we can get your questions answered here too. Do that. So you
All
can,
right, we have a question from Paula. It's okay. Do you have to renew your patent? Is her question.
So you cannot renew your patent. You can only, if you see the clause, let me bring that. So this is the best thing to really see. Where is utility patent? Not this one. Why I want to bring that law is so you can get an understanding. You cannot technically renew the patents, but you can, if you made an improvement to the technology that is almost coming to expire, you can basically add something like came up with something that will improve from previous invention. You can file for another patent application, but there is no renewal in the patent process. It's just one time you get a patent for 20 years, that's it. I'm trying to still find that slide. Yeah. Any further questions? Oh, Paula, that answered your question about renewing your patents. Yep.
Okay. I don't see any other questions in the chat.
I do have a question. Thank you. This is Paula. This was very helpful and appreciate you doing this, your organization. one of the questions I have is reference to what you just mentioned. So there's the patent offices at some of the universities like USF. So if you wanted to improve on that patent, is that somewhere you can go and get information more about how to make improvements? Or since it's only a 20-year limitation, or where would you find, what qualifies for you to be able to make an extension to the patent?
So, co- um, to qualify for any kind of patent, right? If you, and I'm guessing that you're mentioning the UCF campus that has the PTRC Center, which is the Patent Trademark Research Center. If you
Yes.
there, and let's say you came up with some kind of patent that's almost expiring, and now, like, just pharmaceutical drug, let's take that example, simple. You created an ibuprofen that, kind of targets your pain, but now you created a ibuprofen after just about finishing your that 20 years term limit, and you're thinking that, I can just create that tablet to improve pain localized in that, let's say, it's in my elbow, so I just want to target the elbow area instead of just spreading whatever, just creating something out of my hand. You can then just do research, right? And PTRC resource centers are going to help you look for that kind of specialized improvement that you're trying to do. So you're just going to get some overview about it, that, okay, I see there's not much, and then you have to make that decision. End of the day, you are the one who's coming with that creative idea, right? So you have to make that decision that, okay, I have enough background, I have enough historical data that nobody has come up with something, so maybe I should apply for it. And
Very
again,
helpful, very helpful. Thank you. I needed that clarification. That's your expertise. So I needed that additional help. Sometimes, you might assume certain things, and I'd rather hear more because you have the knowledge base. So I appreciate this was very dynamic. And thanks for the link as well for membership for myself and others that might be interested in the Black Innovation Leaders of Florida. Appreciate all that you guys do. Thank you.
no, thanks, Paula. And again, somebody also mentioned about the what's the best path to file or get any kind of. We always, as I said, advise legal consult, because it will really streamline your process, and it will be more efficient and cost effective sometimes. But again, to be most cost effective, knowing all this and all learning from all kind of this educational presentations, it will help you also make yourself aware of everything, so you can basically be prepared when you go talk to somebody.
One quick question. Did you provide any kind of ballpark figure, how much it costs, like, to file a patent?
I did not, but here I'm gonna pull up this and show you guys quickly. So if you go on USPTO's main website, can you see this, everybody, right?
Yes.
And I think you can type, just say, I'm gonna just type utility patent fees, right? Or fees also. If you click on fees, it's gonna search. So here's the filing guide, USPTO fee schedule. So if you click on that, so this gives you all the fees that are included. But there is one slide in one of the extensive patent presentations we have. Usually, inventors or any company filing for patent, the fees are approximately around $1,800. But if you qualify for a small entity or a micro entity, then for small entity, the fees are discounted to 60%. And for micro entity, it discounted to 80%. And again, I think the previous presentation that last week I did gave you the breakdown of that too. So like 2,080%, just roughly, I'm doing the math. 16, so $400 you would pay for, for your as a micro entity status. And for micro entity, again, you can search micro entity in here, and it will tell you what is the qualification for that. And usually here is the micro entity status. So this will tell you that if you didn't file more than 4 patents, but after filing more than issued 4 patents, you might fall under small business, small entity status. But this will give you every detail about it too. And if you want, I can just put this into the link so you guys have the access to this. And our website is great, giving all kind of things. So whatever you think of, you feel like, I have doubt, you can first go and search here in this search window on the right top.
Okay, great. Thank you.
you.
Thank you. And I have one last question, and that's going to be kind of like your opinion. One of the things that we hear a lot is that, sometimes it's better not to file a patent because the quality of your patent is in your ability to enforce it. Meaning, once you file a patent, you got the patent, the information's out there, and somebody infringes upon it, but you don't have enough money to, pursue any kind of court action or, to enforce the patent, then because it becomes pretty much useless. What is your opinion on that?
I think we usually, again, it's up to the inventor itself. Comes to their own, its onus is on them, basically, right? End of the day, it completely depends. That's why they have to do the market study that, hey, I've come up with this product. Do you think, is it feasible if I should file for a patent? Or should I just, make the product and just make money out of it? So that whole leveraging of what's beneficial, I don't know. I cannot, everybody is individual case by case basis. So I cannot give you complete straight yes and no answer. But it is purely on the inventor and to decide, is it going to be beneficial, right? Or not.
Right. But if you don't, if you don't pursue, let's say that you're aware of somebody's infringing on your patent and you don't pursue it, does that somewhat affect your patent itself? Or it has nothing to do with the patent? Like it's complete.
Well, if you're saying that if you are not gonna go with the filing of patent, right, and somebody's infringing, it doesn't matter at that point of time.
No, I'm sorry, if you file a patent,
okay,
but you don't have the funding to pursue infringers in court, so you don't have enough money, or to
yes, again, that again comes to, let's say you have a patent filed and you have an infringer and you don't have the money. That's what you're asking exactly, right? It all depends on, if you have an investor and he sees there is a potential, that maybe then you can tie up with them, right? And you can get the resources. If they feel like your patent has some amazing potential, this is where that business as IP strategy, one of the presentations we do, it kind of talks about it. And we had surfaced a little bit on that slide, not too much, but that's where it all boils down to is, if I see a potential, why not try to tie up or have some kind of an agreement with whoever potential investors are to decide that we should pursue or not, or just let it go if you think that it's not worthwhile. So again, it comes down to your individually what you have discovered, right? What you think is potential or not. So I mean, there are
Okay.
people who have done quite a bit, come up with processes of, sending out coupons, just an example. But sending out coupons is a so uh, ubiquitous process that everybody's been doing it. So how are you benefiting yourself? Is there a certain way you can, it will change people's, whatever lifestyle or whatever of receiving coupons and implementing, and you can make an impact? It's all based how you're gonna make money out of it end of the day.
Okay. So, I don't want to drag this too long because I know we probably have a hard stop. But what I'm trying to figure out is you have a patent with the office, with the USPTO. So you have the right to pretty much, like you said before, you have a legal monopoly.
Yes.
But if you, for example, are not actively enforcing your right, does that diminish the quality of your patent? Does that is there any kind of reflection on the USPTO, or is just you have the right, so it's up to you to enforce it? If you don't enforce it, that's your problem. Or is it like, well, you didn't enforce it, so the USPTO is not like, your patent becomes null and void? That's what I'm trying to figure out.
Oh, so USPTO is the whole idea of the patent agents, the United States Patent Agency, is basically we don't enforce or anything. We just basically this is where you come and file for patent applications and we issue patents. So they are well known that you have a patent, we have a system set to, as I mentioned in the, the historical foundation of why it was set up. So we have one step before, you get a patent, and then it's purely up to the legal consults or the lawyers that you hire to really go after or perceive that. So we don't we don't get into that. We are just still a process where you can maintain and basically get patent issued or trademarks, and then you maintain with our office basically.
Okay, got it. So it's more like a registration process where, you get approved and
Yes.
right. So you register with the government as the owner of this patent,
Yes.
or this right, monopolistic right. Got
Right. Yeah. And it basically that's where you basically have that power over others, right? Because now somebody is doing it, then we can, as a lawyer, whoever you hire,
right.
they're gonna say that, hey, you do have a patent and it was issued by patent office because we are recognized by that. So that's where it all will boil down to.
All right. Thank you so much.
No, anytime.
All right. Well, with that, we are at the end of our session. There are no more questions in the chat. So we want to thank you again to the USPTO office for joining us today for this presentation, and thank all of you for attending. And we will be back for the last 4-part series session next Tuesday, same time, same place. Thank you all. Bye.
Thank you. See you guys.